Hello everyone, welcome to our webinar regarding withdrawal liability and pensions. This is the third webinar in Conn Maciel Carey's 2019 Labor and Employment webinar series. Thanks again for joining us, and we look forward to an interesting discussion today and each month the rest of 2019. Okay, welcome everybody. This is Mark Trapp. I'm an attorney in the Chicago office of Conn Maciel and Carey. Get going. I titled today's webinar, We're Not Going to Take It, Avoiding, Minimizing, and Fighting Withdrawal Liability. We'll jump right in, minimizing and fighting withdrawal liability. I've rearranged a lot of this. I've done a fair amount of these presentations, and I've refined this, and I think that maybe this will be a good format to follow for business owners and those concerned about multi-employer pension withdrawal liability. We're first going to talk about ways to avoid withdrawal liability. This will be mainly business planning issues and estate planning, control group issues, things like that. Then we'll talk about what to do when you're already sort of in the mix and you need to try to minimize your withdrawal liability. And then after that, we'll talk about what happens when you get hit with an assessment and you actually have to fight the withdrawal liability. So let's start there. Business planning to avoid withdrawal liability. I'm going to dispatch with most of the introductory items about the Multi-Employer Pension Plan Amendments Act. That's the MPPAA that's referenced there. I assume that most people on the call have at least a fair understanding of the background of withdrawal liability and the situations that it has created for your business. So I'll just say essentially it's an exit fee. It covers the unfunded vested benefits of a plan, and the unfunded vested benefits are generally the difference between what's been promised to the plan participants at retirement versus the money that is there to cover those promises. There's usually a large discrepancy these days, and that means there are vested benefits which are unfunded. As you'll see, each employer that participates in a multi-employer pension plan is allocated their portion of the unfunded vested benefits. Withdrawal liability is sort of a liability that's not quantified or exactly known until it's triggered. And there's several ways to trigger it. Generally, you reduce or cease your obligation to contribute. There's various ways that can happen. One thing I'll point out now is that a failure to make contributions that are due under your collective bargaining agreement does not trigger a withdrawal. It's not based on actual contributions, so if you over-contribute or under-contribute or just stop contributing, it's based on the legal obligation to contribute, as we'll see here. On the next slide, a complete withdrawal occurs when you permanently cease to have an obligation to contribute, or if you cease all covered operations, because that legally ends your obligation to contribute. That can happen if you close down a plant or a facility, if you sell the business, if you bargain out, that is, your collective bargaining agreement no longer includes in it an obligation to contribute, or if the union decertifies. You can even be expelled by the fund. A lot of the funds will implement what they call adverse selection and expel employers. That would also result in a complete withdrawal. Partial withdrawal happens in one of three ways. Excuse me. Generally, where there's a 70% decline in contributions over a 3-year period that's sustained for all 3 of those years, then that can trigger a partial withdrawal. And there's a little formula that goes with that, which I won't bore you with, but just know that if you're experiencing a significant decrease in work that's performed for which you have an obligation to contribute, you can, and that occurs over 3 years, looking back, then you can, maybe without even knowing it at the time, incur a partial withdrawal. There's 2 other ways. These are known as a CBA takeout or a facility takeout. They're spelled out there on the slide. It's where you cease to have an obligation to contribute under one but not all of your CBAs, and you continue to do the work that was performed under that CBA or transfer it to a different location. Or if you shut down one facility and continue, if you stop having an obligation to contribute at a facility, but you're still continuing the work for which you previously contributed at that facility. That's a facility takeout. So those are the ways you can trigger a partial withdrawal. There's also something known as a mass withdrawal. This is where all or nearly all of the contributing employers withdraw. The plan will terminate in a mass withdrawal. The liability will be apportioned between all the employers, including this reallocation. Reallocation is kind of interesting. That's the amounts that are deemed not otherwise collected or collectible by the plan. This is generally amounts that are not collected due to bankruptcy of employers or things like that. So you could end up getting stuck with your neighbor's benefits as well. Many of you may be familiar with that. This idea of orphans, well, that happens in a mass withdrawal situation too, where all the unfunded vested benefits are reallocated. Also, the 20-year cap is no longer applied, and we'll talk a little bit about the 20-year cap a little bit later on. They try to bring employers back in who withdrew during the prior 3 years and say that those employers are presumed to have withdrawn pursuant to an arrangement with the other employers and are therefore treated the same. That can be rebutted. There are other issues dealing with mass withdrawal. It's not a common occurrence, but it is something to be aware of. Many of you may know of different rules that are applicable in certain industries, such as the construction industry rules, and these rules modify the conditions under which a complete withdrawal occurs or when the employer is liable in the case of a partial withdrawal. And as specified there on the slide, the construction industry special rule. This, in the construction industry, a complete withdrawal occurs only if the employer ceases to have an obligation to contribute and either continues to perform the covered work or resumes such work within 5 years. As I note at the top of the slide, there are other industries that have special rules, including entertainment, trucking, retail, food, etc. Again, this first portion of the presentation is all things to know to avoid withdrawal liability, and one of these main ones is control group liability, this concept of control group. ERISA treats all trades or businesses under common control as a single employer and imposes joint and several liability on those companies. The key to this is that the fund can seek payment from any member of the control group. There are attribution rules, much like there are in the IRS proceedings or the tax code, that ownership of a business can be attributed to a person who doesn't own it, maybe through spousal relations or minor children, things like that. So watch out for those rules. And we'll talk a little bit more about this, but you'll see courts have held that businesses don't need to be economically related to be within the same rubric of common control. Let's talk a little bit about what a controlled group is and why you should be aware of it. Excuse me. Controlled group is two or more organizations that are first trades or businesses and second under common control. Let's deal with the second factor first. Common control would either be like a parent-subsidiary relationship between these entities or brother or sister, as they call it. The important thing to know here, I won't focus for purposes of today's presentation on the details of the tests, but just know that the obligation to the fund that you may have through one entity may not be limited to that signatory company, the company that signs the collective bargaining agreement. could be spread across any member of the control group. And as I mentioned, the control group could be a parent-subsidiary relationship, a brother-sister relationship. It's basically if they're common ownership across these of 80%, or in the brother-sister relationship with the additional 50% effective control. The general idea here is that if you have entities that are owned or strongly affiliated with other entities, then those entities can all be responsible for any withdrawal liability. As I note there at the bottom of the slide, liability is joint and several, so the control group can be of extreme importance. Now we'll get down into some examples here in a second after we finish laying out the other prong of control group, which is a trade or business. You have to have a trade or business. What is that? Well, it's an organization engaged in an activity, one, for the primary purpose of income or profit, and two, with continuity and regularity. Well, what does that mean? We'll start with sort of what it doesn't mean generally is if you're working as an employee, that's not a trade or business. You're just getting income as an employee. Passive investments, hobbies, some of the court opinions refer to this as amusement diversions. That's generally not a trade or business, although it's been somewhat in flux in recent years as floundering funds have cast around looking for other pockets in addition to the withdrawn entity and tried to bring in all sorts of other entities. It's something to watch out for. Know this, that as I make the point here at the bottom of the slide, it extends to leasing activity and earnings as an independent contractor. So, for example, the owner of a withdrawn company might expose his personal assets if that owner leases other property to third parties, even if it's unrelated to his company, or earns income as a consultant, like 1099 income. That could be considered a trade or a business and part of a control group. I'm in Chicago, and here in the this is in the Seventh Circuit Court of Appeals, and this is generally followed in other circuits, although a lot of these decisions occur here in the Seventh Circuit. And I want to talk for a minute about this leasing property rule that the Seventh Circuit imposes as a, quote, categorical rule. And that is that if you're leasing property to a withdrawn employer, that makes the entity a trade or business. And I cite this case here, this Hanna Brothers case. The Hanna Brothers case ran a tugboat business, but the tugboats were leased to that employer by the owner who owned both of the companies. And that created a control group which made the entity that leased the tugboats also responsible for the withdrawal liability of the withdrawn employer. Here's another quote from a case that's illustrative of the broadness of this principle. This is from the Beeland and Uyghurs Enterprises Incorporated case, as it says here on the slide. In sum, if an individual engages in a trade or business under common control with the withdrawing employer by leasing his property to the withdrawing employer, he is personally liable for payment of withdrawal liability. Now, the general rule for withdrawal liability is there is no personal liability. That's sort of the standard. But as I'm trying to point out here through this control group issue, you can make yourself personally liable through these other entities as part of a control group. And as simple as leasing property. And what often happens is the owner of, say, a trucking company will lease the equipment, the trucks, or the building out of which the company is run to that company and take payment from that company. And they may not even have set up a separate leasing entity or any other entity at all. They may own the building individually or own some of the trucks individually and lease them to the company. And that activity could be held to be a trade or business if, for example, the signatory entity goes out of business and is assessed withdrawal liability and doesn't have any assets left to satisfy it. The fund will look around and say, who else can we go after? Oh, you leased property. You, the owner, leased property to the withdrawn entity? Okay, well, that's a trade or business, and therefore, because you own both of these entities, you are a part of a control group, and we can collect it from you. So I laid out these 3 rules here that are pretty categorical in the Seventh Circuit. First, where the individual owns the property on which the withdrawing employer conducts its operations, leases the property to the withdrawing employer, and third, owns the withdrawing employer, then that individual is personally liable for the payment of withdrawal liability incurred by the withdrawing employer. That's kind of a harsh rule, so you need to know as a business owner what other entities might be part of your control group. Let's see here. In addition to leasing, courts have found other minimal real estate investment activities to be a trade or business. Here's another Seventh Circuit opinion. This was one where this family limited partnership was found responsible for $4 million withdrawal liability of a commonly owned trucking company. So they owned the trucking company, and they'd set up this limited partnership that also owned a family vacation property. And for that family vacation property, they had claimed various tax exemptions, claiming it as a working farm, and they had like maybe 1 employee on the farm, and I think on some of their tax returns they had claimed something, $10,000 or $20,000 worth of income or something over several years. And that was held to be a trade or business, and so that limited partnership was found liable for the $4 million that the trucking company could not satisfy. Let's see, what else do you need to know about control group liability? If you receive notice from the fund, and we'll talk later on in the presentation about what the notice is, but it's generally just a letter. Notice to one member of a control group will generally count as notice to all. So if you're part of a control group and one entity gets the assessment, the other entities can't sidestep their responsibility for it by saying, we never got the notice. We didn't know about any of this. And as we'll also see later on in the presentation, arbitration is very important as the first and necessary step to challenging any assessment. If one member of the control group gets that notice and doesn't jump through the hoops and follow the procedures to challenge the assessment, then later on, when the fund goes after a control group member, that control group member may have lost its chance to make any arguments against the assessment, because the notice to the first control group member can be held effective as against the other members of the control group. You might also note here that the control group is determined as of the date of withdrawal. So if the control over the withdrawn entity ceased before withdrawal, then there would generally be no liability for the other members of the control group. But we'll see here in a second there's an exception to that. And as I've already mentioned, you have to exercise your right to challenge, or you might waive it. So notice to one is notice to all. There's also a brief note here that I won't dwell on too much about this alter ego concept. This is a concept that many of the courts have borrowed from labor law, holding that an entity can be an alter ego of another if it has substantially identical management, ownership, business purpose, customers, things like this. Then one business could be held to be the alter ego of another business and responsible for that other business's withdrawal liability as well. Now this is kind of an interesting concept here, is this concept that's spelled out in the statute that I cite on this slide, dealing with evade or avoid transactions. the statute says that if a principal purpose of any transaction is to evade or avoid liability under this part, that is this part of ERISA, this part shall be applied and liability shall be determined and collected without regard to such transaction. So the funds will get to ignore that transaction. And this comes up in control groups. If you look at the slide that we were just on where I said the control group is determined as of the date of withdrawal up there. That's generally true, but some funds in recent years have taken to saying, oh, well, you engaged in that sale transaction to get rid of that part of the control group before withdrawing, and guess what? That was done to evade or avoid withdrawal liability. Therefore, we'll ignore that transaction. And they've done that with many other transactions too. This 29 U.S.C. 1392 is a very the funds view it as very broad, and they use it aggressively. So be aware of that, the funds can try to set aside and ignore transactions that they don't like, that they think that you entered into to avoid withdrawal liability. This doesn't have to be the sole purpose of the transaction, just needs to be one of the factors. That also comes from a Seventh Circuit opinion. And you should be aware of this because funds will use it to try to get around transactions that they feel put them at a disadvantage. So what else do you need to know here as a business owner? What if you're trying to sell your business or divest yourself of it? What do you do? What if you're changing the structure? Well, as you see here on this slide, a change in company structure or organization is generally okay if the obligation to contribute is not affected, that is, if it continues. Below that, I make the point that an asset sale will trigger a withdrawal unless the parties comply with the requirements of Section 4204 of ERISA, which I'll discuss here in just a minute after we talk a little bit about successorship liability. Successorship liability funds are increasingly using that to go after purchasers of assets. And so there's a couple ways to examine this from both the buyer and seller's point of when you're buying or selling a business that has obligations to a multi-employer pension fund. I'm not going to focus on either, but you just need to be aware. Well, I shouldn't say it that I'm not going to focus on either. I guess I'll focus on it as sort of like on both sides of it. I'm not picking one side or the other, but just know that if you're buying, certainly if you're buying, you want to be well aware of this. And if you're selling, you want to know that that might trigger a withdrawal and what you can do to avoid that. As you see at the bottom of this slide, the sale of assets will end your obligation to contribute. It will trigger a withdrawal. There is a limitation on the allocable unfunded vested benefits. That's that UVB there on the slide. Remember we talked about that earlier, your portion of allocable unfunded vested benefits. There is a limitation on that of 5 years that I'll mention here again in another slide or two. And the Section 4204 that I mentioned, if you comply with that, that can avoid triggering withdrawal liability. And I'll revisit that in just a couple slides as well. So successor liability, what's the deal with successor liability? Well, the common law rule has generally been that an asset purchaser would not be liable for the seller's liabilities. In the withdrawal liability context, this has increasingly been ignored to employers' detriment. That is, this common law rule has basically morphed into a common law rule of the federal courts that an asset purchaser may be liable for the seller's withdrawal liability, and that they couldn't use the general common law rule to avoid it. The factors that they look at are did the purchaser have notice of the liability prior to the sale, and is there sufficient evidence of the continuity of operations after the sale, such as continuity of workforce, management, equipment, completion of work orders, consistency of customers, etc. And I cite a couple cases down there. One of them is pretty recent from the Ninth Circuit just last year. This first one, Resilient Floor Covers Fund, This one came out a couple years ago. It dealt with several of those factors and held that the taking over the customer base was like the most important factor. So when a successor purchaser came in and took over the customer base, the court really focused on that as the key to trying to hold the that purchasing entity liable for the withdrawal liability of the seller. There's one here in the Seventh Circuit, Saref versus ManWeb Services. The notice of liability, this was construed very broadly here by the Seventh Circuit. And I'll go on to the next case, this Heavenly Hannah Hotels, because it's gotten even broader. And here in this Ninth Circuit case, Heavenly Hannah, the Ninth Circuit held that even constructive notice of the withdrawal liability was sufficient. And that case puts the onus on buyers to investigate the funded status of the plan. I'll hit you with just a couple thoughts about these. In that ManWeb case in the Seventh Circuit, the court said this: shielding a successor employer from liability when the company had knowledge of the potential liability and still had bargaining power with regard to the transaction runs counter to the policies underlying the doctrine of successor liability. What does that mean in English? Well, the court was saying, hey, if you had knowledge of the possibility of withdrawal liability, i.e. by virtue of knowing that the company that you're buying contributed to a multi-employer plan, or in some cases the courts have said even if you knew that the company that you're purchasing was unionized and therefore might contribute to a multi-employer plan, then guess what? You have power with regard to the transaction to factor that in. And if you don't, well then guess what? You may be liable. The Heavenly Hannah case, like I said, went even a step further and found that a failure to investigate the pension liability and a reliance on the representation made by the seller in the asset purchase agreement was not sufficient. So that court found that the buyer had constructive notice of the liability. And it was interesting, in that opinion, the Ninth Circuit said that the buyer noted that the buyer had a 4-person due diligence team for the transaction, that they had hired engineers to look at the roofs of it was a hotel that they purchased, the condition of the structural features. They brought up termites. There was some representation made as to termites, and the purchaser had hired engineers to look into all of those issues. And the court said the buyer did not rely on the seller's representation regarding termites, but did rely on the representation made as to withdrawal liability, which was worth many millions of dollars. And the court said, quote, this reliance is unreasonable. So it sort of put the onus on the buyer to investigate and find out, and wouldn't allow the buyer to sidestep that liability by saying, well, we relied on what the seller told us. So again, just a summary here of some of the factors that the courts consider. Is the purchaser using the same physical assets, the equipment, the building? Do they take over the customer base, or are they filling orders made by existing customers? The continuity of management. Did you take on the employees? Are there other assets that you took, like the goodwill or trademarks? Do you hold yourself out as operating the same business? And then importantly, did the buyer have notice, even constructive notice, which I've already talked about. So this will get us, this Section 4204 slide will get us back to, well, what do you do as a seller if you're selling your business and the sale of assets is going to trigger a withdrawal? How do you avoid that? Well, you can comply with this Section 4204 of ERISA. Which says that a withdrawal is not triggered in an asset sale if certain conditions are met. If it's a bona fide arm's length transaction with an unrelated party, the purchaser has to keep the obligation to contribute for substantially the same number of contribution base units. Contribution base units are whatever unit you use to contribute to the fund. That's by hour or week or day, whatever that happens to be. If it's $4 an hour, then the contribution base unit is hours. and the purchaser has to post a bond for 5 years, and then the third prong is the seller has to agree as part of the sale contract, that has to be in the asset purchase agreement, to secondary liability within the first 5 years. So even if you sold your business and complied with 4204, if the purchaser defaulted on that obligation, the fund would come back to you through that Section 4204 agreement. You can't apply for a variance to posting a bond as a purchaser. You can apply with the PBGC and avoid posting a bond if that's approved. What are some things to know about Section 4204? Remember I mentioned back a couple slides ago that a buyer would assume just 5 years of contribution history. That's kind of important because, as we'll see here later on, generally when the fund is determining withdrawal liability, we'll look back 10 years. Well, if you buy the assets of an employer, you're only assuming 5 years of contribution history. And if that employer's highest contribution years were more than 5 years but less than 10 years prior, then some of those, that employer may have a bigger withdrawal liability than its purchaser would, because those high years would not count against the purchaser, and that'll become a little bit more clear when I lay out how you calculate the withdrawal liability, and more specifically the annual payment in a few slides. So in any event, the buyer needs to analyze the successorship pretty carefully, conduct thorough due diligence. You can, as the Seventh Circuit opinion was noting, you have power with regard to the transaction, and if you're looking at purchasing a unionized business that contributes to a multi-employer pension plan, you should negotiate a price reduction if you take it on, or escrow the money, or some entities even try to force the withdrawal and payment of it by the seller even as part of the transaction. And oftentimes, just know this, the transaction may not be worthwhile, might not be in your interest to buy it. And that's just the sad truth of many of these transactions. So what are some key points to avoid liability here? Business planning. I'm sorry, it looks like I misspelled that. I'm sorry. Key points, it should say. Business planning. Conduct thorough due diligence. Watch out for the successorship concept. If you're purchasing any assets or businesses, account for that liability. Be very careful with it. And also, even if you're just running your own business and you're not purchasing any others, make sure you're careful with your estate and business planning so that you know this control group concept, and know what other entities might be perceived as trades or businesses by the fund if your company, say, is going out of business and might not have the funds to pay the multi-employer fund. That's mentioned down at the bottom of the slide too, the control group. Pay attention to whether or not you're leasing property or equipment to the potentially withdrawn entity. And then one other point here in the middle is if you're negotiating collective bargaining agreements, or even if you just have a collective bargaining agreement, which I'm sure you all do, make sure that your contributions are in accordance with it. And what I mean by that is I often find employers that have they've been over-contributing for some reason. Maybe it's just the way they've done it. They didn't pay attention to the subtle language in the contract, and so they're contributing on overtime hours, for example, where the contract specifically excludes overtime hours. They've contributed on vacation hours, and the contract excludes vacation or leave. Or there's caps. A lot of these contracts will say, no more than 160 hours a month, or 173, or whatever the number is that they've picked. And sometimes employers aren't paying attention to that, or one hand is not watching, one department is not aware of the contract, and so they're just calculating all the hours and sending off the payment, and you may be paying more than you should, and you just want to make sure of that because your contribution history can help determine how much you owe the fund if and when you ever withdraw, so just be careful about that. One final point about collective bargaining there would be don't just blindly accept rate increases and ensure that proper language is included in your agreement under the MPRA, the Multi-Employer Pension Reform Act. This just came out in 2014. I haven't seen a lot of employers do this, but I encourage them. If you're going to agree to increases, even if you're staying in the fund and your fund is in critical status or endangered status and it has a rehabilitation plan and they tell you this is the schedule, you have to accept it, that's it, these are the rates. You may end up having to accept that, but you ought to ensure that you include language that says we're including these rates only as part of what's required under the rehabilitation plan. And you'll see here later on, and I'll refer back to this moment later on when we talk a little bit more about the Multi-Employer Pension Reform Act and specifically a recent proposed regulation by the Pension Benefit Guarantee Corporation. Okay, so that's avoiding. Now let's look at minimizing. Okay, you're already sort of in this. You've already got your collective bargaining agreement. You know you've got some withdrawal liability somewhere. It hasn't been triggered, or you'd like to avoid that. And what do you do? What are some things you should know about lessening or reducing the impact of withdrawal liability? There's a couple of relief provisions. We'll talk about some of these, and then there's some limitations. All right, this is where you need to know how to calculate withdrawal liability. And oftentimes, even many of you on the call probably have received estimates from the fund as to what your withdrawal liability would be. And they send you a note and it says, dear so-and-so, if a withdrawal for this year, and it's a year prior probably because it takes them that long to get the information, they'll say, you owe us, $15 million for a withdrawal. I've never seen a fund actually give you the right number there. And I don't mean they're liars. Well, what I mean by that is that number is almost invariably your unfunded vested benefits, your allocable portion of the unfunded vested benefits. Because so many of these funds are over the cliff these days, that number is pretty high. What they haven't told you, even though it's an estimate of, quote, withdrawal liability, they haven't told you the fundamental difference between withdrawal liability and unfunded vested benefits. Unfunded vested benefits is the starting point to calculate withdrawal liability. At the end of that calculation, you have, quote, withdrawal liability. And one thing that they leave out is the application of the 20-year payment cap, which we'll talk about now. Your liability is limited to 20 annual payments. Your annual payment, we'll talk about how you calculate that in, I think, the next slide. But just know that that number on your estimate may not be liable or reliable, probably is not, because what they've given you is almost certainly your unfunded vested benefits. If your fund is in bad enough shape, and I'm sure for many of you it is, then your 20-year total of payments would be much less than the amount of your unfunded vested benefits. In any event, your unfunded vested benefits is generally in proportion to your historical level of contributions relative to everyone else's. And if there's an amount, this you guys probably already know, but it shows how scary this whole idea of withdrawal liability is. De minimis amounts are generally between $50,000 to $150,000, where they just say, all right, forget it, it's not even worth it. And that tells you what kind of amounts we're dealing with here. We're generally speaking millions, even for small family-run companies, and it's usually a sort of bet the company sort of proposition. Let's talk just briefly then about the Section 4205 limitations. This is also a part of ERISA. It can be substantial savings, and I don't see a lot of people talk about this either. If you engage in a sale of assets and shut down your business, and it's all bona fide and up and up, it can substantially limit the amount of unfunded vested benefits that the fund can allocate to you. They have a chart in the statute. It's generally you get they can charge you with a portion of the liquidation value of the assets that you sold. And I think that the first step on the chart goes up to like $5 million. So if you're a small business and you're looking at a bunch of liability and you sold off the assets and we'd have to talk about how all that went down, but applying that limitation could severely limit the amount that the fund could collect at the end of the day, and that's something that you need to be aware of also when you're contemplating options and looking at these estimates that they send that scare you and keep you up at night. Same with, there's an insolvency liquidation limitation that's in the same portion of the statute that can result in pretty significant reduction of withdrawal liability if an employer declares bankruptcy or is insolvent and undergoing liquidation. Should talk about that as well. One other thing you should know about minimizing withdrawal liability is the timing really matters under the statute. Under ERISA, the date of a complete withdrawal is the, quote, date of the cessation of the obligation to contribute. And the reason this matters, I'll just tell you quickly, I had a case several years ago where a fund expelled our client and they wanted to bleed us dry for every contribution, so they waited until the last day of the year. The fund year ran from January 1 through December 31. And they let us make contributions right up until the end of the year. And on December 31st, they sent us a note that said, hey, by the way, we're kicking you out, and effective as of January 1, you'll no longer be a contributing employer. Well, that was a big mistake on their part because the plan year can make a huge difference in withdrawal liability. It's calculated annually and runs by plan year. And so when they said effective as of January 1, guess what that did? It put us into a different year from December 31. And that year difference actually redounded to our benefit to the tune of something like $2 million or something. And they didn't like it, but that's the way it went down, and we came out on much to the good on that one. So know that, and especially if you're thinking, hey, I've got this business and I need to shut it down or something, or I need to sell or whatever. No, pay attention to when that takes place and know what is the plan year for your fund, because it can make a difference what year these things happen. Or even if you just limp along through another year, you might have some of your high year contribution base units drop off, as it were, and reduce your withdrawal liability that you might ultimately be responsible for, either you or as part of a control group. So know about the timing. That makes a big difference. Here's why. Calculating your payment. Many of you may already know this, but when you look at that number on the estimate that I just told you they scare you to death with, that's probably your unfunded vested benefits. The way you calculate what you would actually pay is you look at your contribution base units. I already told you that's the unit under which you're obligated to contribute. Hour, day, week, what have you. Mostly it's hours, sometimes it's weeks. You look back at the last 10 years, not including the current year, and look at your CBUs for those 10 years. You take the highest 3 consecutive years out of those 10 years and average those. That's your high year CBU, as it says down below in the formula, annual payment. Your second factor is your contribution rate. You look at your highest contribution rate in your last 10 years. You multiply that with the high year CBUs, that's your annual payment. The 20-year cap then comes in because they can make you pay that annual payment for 20 years, no more than 20 years. If you owe $10 million, but your annual payment is $250,000, well, guess what? $250,000 times 20 is $5 million, I think. And as long as I'm right on that, then it's $5 million. Well, guess what? If you had $10 million in unfunded vested benefits, you're not paying the other $5 million. That's the most they can make you pay. And that's why it's important, because when you look back 10 years at your contribution base unit history, that's why I was suggesting, depending on the timing, some years might fall off as you progress. And maybe your business was doing great 10 years ago, and so you had much higher CBU levels. When that drops off, then your annual payment drops, and so does your withdrawal liability. There is a point there to be made about this MPRA, the Multiemployer Pension Reform Act. This passed in 2014, and there's a section of the statute that says that increases in the contribution rate required or made in order to enable the plan to meet the requirement of a funding improvement plan or a rehabilitation plan shall be disregarded in determining your allocation of unfunded vested benefits, and this is the key, the highest contribution rate. That is, if your fund is in critical status and has a rehabilitation plan and has mandated increases, after December 31st of 2014, you should have an argument that those contribution rate increases should not count against you as the highest contribution rate, and that may be really good for you in determining your annual payment. Because maybe some of your high-year contribution-based unit years are dropping off, and your 2014 rate that you would use to multiply against that is not increasing, at least for purposes of withdrawal liability. So that may provide an opportunity for you. Now there's a big caveat to that now. The Pension Benefit Guaranty Corporation just came out last month with a proposed regulatory change dealing with these contribution increases. And lo and behold, I've had some of these funds have argued against the application of the Multi-Employer Pension Reform Act that says you don't count the rates that were mandated by rehabilitation plans after 2014. And they say, well, no, that doesn't apply to us because our contribution increases are, quote, benefit bearing. Well, lo and behold, they must have a pretty good lobbyist or something, because the PBGC just released a proposed regulation, and under their method of calculating the highest contribution rate, they say, well, you should include these so-called, quote, benefit-bearing contribution increases. And as soon as I saw that, I thought, what the heck is going on here? And I think that it's wrong. I think it contradicts the statute, and I'm hoping to get together a group to file some comments about that, because there's about another month left to do so. But if any of you on this call are interested in participating in that somehow, please contact me afterwards, because I'd love to get together a little group and file comments, because I think it contradicts the statute, and I think it directly contradicts the statute. And we need to do something about it to prevent the regulation from allowing the funds to basically screw the employers out of the benefit that was enacted as part of the Multi-Employer Pension Reform Act. And that is a huge amount of money that we're talking about for individual employers. It's usually going to be, from 2014, if you're looking at 4 or 6% increases year over year, by that you're looking at 20, 30% difference in your withdrawal liability payments. That's a lot of money. So that's something to know. I don't think that it's right. I don't think that the funds are right about that, but it's interesting to see which way the wind is blowing, and that it seems like the PBGC has taken the fund side, but I don't think it's very supportable, and we can talk more about that individually, I guess. All right, so what else do you need to know about your liability if you want to try to minimize it? Again, I've mentioned estimates a couple times. You're entitled to annual estimates. There's other financial and valuation reports. You need to know the fund's condition. Sometimes they'll give you, they're required to send you these annual funding notices. You need to know what they're using as assumptions and their investment returns. You can request their arbitration decisions. Those have to be made available to you. And here, if you're not getting estimates of your withdrawal liability, you need to, and you can do it under ERISA Section 101L. There's other stuff you can request under K, but what the most important here is to send something out at least annually to get your estimate of withdrawal liability, and they're supposed to tell you how the liability is determined, include the actuarial assumptions and methods, give you the data, and then this bolded part here, application of any limitations. That's key information, and like I said, I've never seen anybody ever apply that. What they give you is the unfunded vested benefits. That application of any limitations is a clear reference to the limitations, the 20-year payment cap, for example, and they never do that. So that number that they give you is generally inflated, but it still is useful to know which way the fund is going, and most of them are going straight south. So you should be apprised of that, and the way to do it is to make sure that you request these estimates. And let me know, you can send me an email or something. I'll be happy to give you a sort of a template form that you can request these things. And finally, on minimizing withdrawal liability, the timing is everything. Pay attention to the 10-year drop-off, the 20-year cap. There's also arguments about present value, and I'll discuss those here in a little bit. Know your contribution rates and the withdrawal liability, and know this effect of the Multi-Employer Pension Reform Act, and now the potential impact of this new reg that the PBGC has proposed. All right, so that's minimizing. Now what happens if you have to fight it? And we've only got about 10 minutes left, so I'll try to get through this quick, but there's, we should be able to make it. So now you have to fight withdrawal liability assessment. How do you do that? How do you challenge an assessment? Well, arbitration reigns supreme under the Multi-Employer Pension Plan Amendments Act. I always call it a home game for the fund. Things are generally slanted their way under the statute, as you've all probably figured out. The statute itself says any dispute between an employer and the plan sponsor of a multi-employer plan concerning a withdrawal liability determination shall be resolved through arbitration. That is, you have to arbitrate. If you don't arbitrate, then it's like monopoly. You don't pass go. You don't collect $200. You go directly to jail. You need to arbitrate, or else you lose all your defenses. How does this work? Well, you get an assessment, and like I said, it's just a letter. It shows up in the mail, and it's a piece of paper with your name and address on it, and it says, guess what? You owe us, $15 million. Here's the payments. You have to start paying them no later than 60 days from when you get it, and they're supposed to give you a schedule. I'll talk just a minute about that later on, but they're supposed to give you a schedule of payments, and you have to start making those payments from the date that you get the assessment. Even while you move to this mid-step here, this request for review, you have 90 days from the day you get that letter to request review. Your request for review is just another letter, and it's back to the fund. But if you don't request review, your arbitration window, which opens based on that step, will never open. You'll never be able to arbitrate, and you'll lose any defenses that you may have had. So pay attention to, if you ever get an assessment, you need to act on it right away. You have 90 days to file a request for review, and then after that you can initiate arbitration within 60 days after the earlier of the fund's response to your request for review. And a lot of times the funds won't respond because they figure you don't know what you're doing, and therefore you'll wait to hear from them, and by the time you ever hear from them, which is never, your deadline to arbitrate will have run, because it opens up 120 days after your request for review is sent to the fund. So if you haven't heard anything from the fund and it's been 120 days, guess what? Your 60-day window to arbitrate just opened. If you don't initiate arbitration in those 60 days, you lose the opportunity. Also, you need to know about the pay now, dispute later. Like I mentioned, you have to make the interim payments even while you're disputing the assessment. Those have to begin within 60 days. And then there's this concept of default, which you may, again, you can email me for this too. I've written this article on default. That's a short article and lays out some of this. But these funds will try to declare you in default, either if you miss a payment or if you've if you shut down your business or declared bankruptcy or something. They'll say, oh, well, look, it's an insecurity default. They have different consequences. Most generally, the missed payment default, they can accelerate any missed payments and declare you in default and say, oh, well, you owe us these missed payments. An insecurity default, they can accelerate the whole amount of the withdrawal liability, and that may be the ball game before you get a chance to fight about it or present any defenses that you have. So if you're interested in that article, it's a short one. It might be interesting. Just shoot me an email. Default deals with the missed payment, deals with the failure to make payments, and they often try to define default in their plan rules as bankruptcy, assignment to creditors, sale of assets, etc. So be aware of that as well when you get any assessment. In litigating assessments, you also need to know about the payment of filing fees and the use of the AAA, the American Arbitration Association. This is my little hobby horse. Unfortunately, it's just another screw job for employers. In 2013, the AAA unilaterally increased its rates to arbitrate from flat $650 fee to a schedule, and the schedule is ridiculous. If you ever take a look at this, it's thousands and thousands of dollars. Most withdrawal liability assessments are more than $1 million, and once you hit $1 million on their schedule, it's something like $8,200 plus another $3,000 or $3,200 payment when you get the hearing. So you're paying like $10,000, $11,000, $12,000 just as a fee to initiate arbitration. Not a lot of employers, especially withdrawn employers or family-run businesses, have that kind of money just laying around, and that's how the funds like it. Funds will put in their own plan document that you have to use AAA in order to arbitrate. That's not in the statute. That's not required under the Pension Benefit Guarantee Corporation regulations, but that's what the funds do because guess what? It makes it harder to challenge their assessment. It's ridiculous. It's unfair. Everybody knows it. The funds know it, and they don't care. You have to pay to initiate the arbitration. They also changed the rules so that the fee is no longer split, but now it's payable by the filing party. Well, guess what? The filing party is always the employer. For good reason, because if the employer doesn't file for arbitration, who wins? The fund. And so the fund forces you, on penalty of losing your opportunity to challenge their assessment, to go to the AAA and pay $10,000, $12,000 just for the privilege to challenge their assessment. It's ridiculous, and I think it violates the law. Unfortunately, the Seventh Circuit has said otherwise without really addressing any of the arguments, and it's funny that the AAA finally got around to filing with the PBGC to approve their application to increase benefits, and the PBGC has just been sitting on it for almost 3 years now. I'm about the only guy in America that filed comments on it, and I think that they don't quite know what to do about it. If you're interested in those, you might be interested to see the comments I filed. They're kind of funny. But just know about that too. Litigating assessments, there's a couple recent developments here that you should know about. There's a couple dueling decisions on actuarial assumptions, and the actuarial assumptions matter quite a bit in determining the unfunded vested benefits and the discount rates. This New York Times opinion came out last March, I think, and said that this Seagal blend, which the funds often use well, generally it increases the withdrawal liability for an employer, and the Southern District of New York rejected that in this instance and said that you had to use the actuary's best estimate. I think that that is consistent with the statute and the intent of Congress. There was this other opinion that came out not long after from the District of New Jersey that said that this was okay. Both of those were appealed. The Manhattan Ford opinion was subsequently settled, but the New York Times opinion is on appeal before the Second Circuit and I think has been fully briefed. I'll have to check to see if they argued it yet or not, but that should be a pretty key decision going forward. And there's one other that you should know about. This just came out in December. And this deals with the credit that should be applied before the 20-year cap. There's been these arguments about how you calculate the credit. If you're an employer and you have a couple withdrawals, like a partial withdrawal, and then it's followed by another partial or a complete, the statute entitles you to a credit for the earlier withdrawal. This issue went to the Ninth Circuit, and the Ninth Circuit, I think, butchered it pretty good because they missed the fundamental difference between unfunded vested benefits and withdrawal liability. And this is what you get from judges, I guess. Like if they haven't practiced in this area and don't know the fundamental difference between those two concepts, all they were doing was looking at the statute and saying, "Oh, this must be how this works." It's wrong. I think it's crazy, but now we're all going to have to deal with that Ninth Circuit opinion and try to steer our way around it because they misread the statute. And the difference matters a lot because of the application of the 20-year cap. The 20-year cap, as I said before, is part of withdrawal liability, and when you limit the unfunded vested benefits by the 20-year cap, that's when you have withdrawal liability. Your credit for a prior withdrawal should be applied against that much smaller number. What the funds have been doing and what this Ninth Circuit opinion sanctions is taking the credit against the much larger number of unfunded vested benefits. Those were amounts that you were never going to be liable for under the statute, and so the funds will take your credit against those. So it's giving you credit against something you never would have paid in the first place, and it doesn't change your withdrawal liability. It doesn't give you a reduction in it, and it's usually worth a lot of money, and it's another raw deal for employers. That issue, I think, is ripe for fighting in other circuits, and we'll just have to see what happens. In any event, it's a big deal. Then always keep an eye on Congress. Last year they established this Joint Select Committee on the Solvency of Multi-Employer Plans. They were supposed to do something about all this. They didn't. They failed, but you never know what these goofballs out there are going to do. And they promised that they were going to find a workable solution in 2019. Central States is hurtling towards bankruptcy, and we'll see how much they can lean on them. But who knows what Congress may or may not do. That's all I've got for you today, and I hope that you benefited from this. If you want any of those articles or a template estimate request letter or anything like that, or have any questions, please feel free to email me at this email address, mtrap@connmaciel.com. It's on this last slide. Thank you so much for coming today, and this concludes our presentation. If you have those questions, I'll be happy to answer them by email. Take care. Goodbye.